Hey, everybody. Welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel. A little bit late tonight, but hey, we're here just like we do each and every Thursday night to talk about all things debt related, whether it's debt collection, lawsuits, bankruptcy, wage garnishment. I'm here to go over your questions and let's have a talk about it. Again, my name is John Skiba. I'm founder of the Consumer Warrior channel. I built this channel for this very specific purpose, to be able to engage with people about these things that keep you up at night, that stress you out and cause a lot of problems. So there are solutions, there are resources out there. I am an attorney in the state of Arizona. I do mostly consumer debt defense and bankruptcy type law, and help people out on the internet like this. So while I am a licensed attorney, I have to give my little disclaimer that I'm not licensed anywhere else. This shouldn't be considered legal advice. And the fact that we're chatting on YouTube does not create any type of attorney-client relationship. Now that I have all my disclaimers out of the way, if you do have a question, go ahead and put it in the chat section, whether you're on Facebook, whether you're on YouTube. I'll put it up on the screen and we can talk about it. I also put a little link in there to SoloSuit. SoloSuit is one of the great sponsors of our weekly live stream. You can go there, check them out. That's a great way to support the channel and the show as well. But they have some great tools on helping you respond to debt collection lawsuits. They have a really slick debt settlement tool that helps you to resolve these things and kind of get them in the rearview mirror. So with that being said, let's go ahead and jump into a lot of questions. We already got a bunch of people there ready to go. Doug was here nice and early. Doug says, hey, I was sued by Discover's lawyers and filed an answer within a week. That was over 3 months ago, and nothing has occurred with the case. Anyway, I can get the case dismissed for non-action. Doug, I can tell you this. In Arizona, where I practice, something I tell all my clients that you have to get in your head is that the wheels of justice, particularly with civil cases, move very, very slowly. And because of that, 3 months in a civil litigation world is nothing. I can tell you that people are shocked when I tell them in Arizona, in our superior courts that deal with cases over $10,000, the amount of time from the time a lawsuit is filed until it goes to trial, on average, is 24 months. Even with simple debt collection cases, it's at least 16 to 18 months. And even in our justice courts, it's about 10 to 12 months. So while I do think the fact that you haven't heard anything could be a basis for you. You could file a motion to dismiss for failure to prosecute. However, I don't think the court would grant it. What they'd likely tell the other side to do is, hey, start doing something and get this taken care of, which is a good thing as well. Or you could hang tight. Depending on which state you're in, you could look at your rules of civil procedure, see if there's a specific time frame that they have to get the case to trial by, and then wait that out and file a motion to dismiss at that point. So, yeah, unfortunately, things go slow in the world of civil justice, and there's just a lot of deadlines. The courts have a lot of cases, those kinds of issues there. So, all right, let's see here. M says, is it true if a lawsuit is filed within the statute of limitations but fails to prosecute it in time, the defendant can get the case dismissed? There's a big theme here, and that is creditors who are not taking action on their own lawsuits. I see that fairly frequently. And that the reason is because usually with debt collection law firms, there's a handful of attorneys. They file thousands of lawsuits, and these things just kind of sit there. Not only that, if you're filing a response to it, you're in the top 5%, because 95% of people don't respond to it, and so they spend a ton of time processing default judgments and then trying to get garnishments and bank levies and that kind of thing squared away. So, all right. And you go on to say Midland filed a lawsuit in March 27th of this year, extension to serve an alternative service method, June 14th, proof of service, last payments with statute of limitations apply since the lawsuit is not prosecuted yet. This is a good question and a kind of different side issue. As soon as the lawsuit is filed with the court, even if they haven't served you yet, even if they haven't done any discovery, if there's no judgment, it's from the day one when they file the lawsuit with the court. That's when that caps the one end of the statute of limitations. So the beginning of the running of the statute of limitations is when the account goes into default, and then it stops as soon as the lawsuit is filed with the court, regardless of whether they've served you or anything like that. And so that's what you need to look at, is that filing date. And that's when you're going to say, okay, has it been more than, in Arizona, it's a 6-year statute of limitations for credit cards. Has it been more than 6 years? If so, then you can file a motion to dismiss, stating that the statute of limitations is squared away. So, all right, let's see. Monterey MX, my man, been here a lot. It says, when is it worth paying extra attorney's fees to attempt to discharge student loans in a Chapter 7? As a general rule, it's always better to pay extra attorney's fees. I'm just kidding you. You're asking an attorney, when is it good to pay extra attorney's fees? But to your point, so the question is, so in bankruptcy practice, Chapter 7 is what most people file. You have a typical practice, and it's usually done on a flat fee basis. Most lawyers, if you hire them for other types of litigation, divorce, those kind of things, they're charging you by the hour for every hour they work. Bankruptcy, particularly Chapter 7 cases, are billed on a flat fee. And so if it's built on a flat fee, usually there's a set amount, and then that covers all the work associated with the Chapter 7. However, almost every bankruptcy attorney I know, they exclude what are called adversary proceedings. An adversary proceeding is kind of like a mini lawsuit within your bankruptcy. It's necessary to get rid of student loans to file an adversary proceeding against the creditor. So, for instance, if this is the Department of Education, you have your student loans, you can't just ask them, hey, can we get these discharged? You actually have to file this mini adversary lawsuit to get get some type of result that you want there. That's typically excluded, and so there's usually attorney's fees. I know I bill those hourly because it's really difficult to be able to tell. It could be something that's really short. It could be something that's really long, and so it's difficult to do that on a flat fee. So is it worth it? Talk to your attorney and see really the factual basis of it. Discharging student loans traditionally has been very difficult. However, right now, the Department of Justice for federal student loans is they really loosened things up a bit. They're allowing things to be discharged on a more frequent basis. Now, student loan discharge is one area that I have seen. I've been doing this for 21 years. Whoever is president, that administration actually impacts that, because they often deal with the, if you file a lawsuit, an adversary proceeding against like the Department of Education, the U.S. Attorney's Office picks up the defense of that. And like right now in the current administration, they're not putting up much of a fight, and they've actually come up with a plan to help facilitate determining who's really eligible and who's not. Other administrations have been more aggressive. So there's a lot of factors that play into it, something that you want to take a look at and talk to. If you have an attorney, sounds like you do, I would talk to the attorney and have them give you some idea specifically on that. Just real quick, in the chat section, you'll see I put the SoloSuit link there. Click there to view some of the tools they have that are awesome. So, all right, Jennifer says, hello, I had cancer, brain tumor, can't work. I owe SBA $200,000. I can't pay them. What should I do? She goes on to say, I own a house. Well, Jennifer, I'm sorry to hear about all those are all tough things. You're dealing with a lot of tough things. And, that's how it is in many situations where the one difficult thing kind of is it creates this domino effect and makes it, the financial component is affected by all these other things going on in your life. Let me tell you this. So, one kind of myth or misunderstanding about SBA loans, Small Business Administration loans that you get through the federal government. Some people think that they're like taxes, that you can't get rid of them, or student loans. SBA loans are fully dischargeable in a Chapter 7 bankruptcy. You can get rid of those. I'm going to give you the kind of one exception to it, but you can get rid of an SBA loan, discharge it just like you can a credit card. And so if you qualify for a Chapter 7, and this is where you got to talk to an attorney in your particular area. If you're in Arizona, my number's down here. I have a link in there. You can set up an appointment. I'm happy to go over it with you. But in a Chapter 7, assuming you qualify for a Chapter 7 bankruptcy, you'll discharge the SBA loan completely. It'll go away. You won't have to pay anything on it. However, to your second point, if you own a house, sometimes SBA loans are secured with collateral. They may have a lien against your home. When you took out the loan, if you gave them a lien against your home or any other collateral, then it's different. Then they're going to get paid their money, or they're going to be able to foreclose on the home or the property, whatever it is that you're doing there. That's when it's going to be a situation where it wouldn't go away. But if it's just a general unsecured SBA loan, which most of them are, then you're going to be able to discharge it. All right. Sachet says, can I file an answer with a motion to compel arbitration? I'm being sued by Midland Funding, and I do have a list. I do have to, and do I have to list the attorney's information on my answer, or just the plaintiff, Midland? So the way that it works, so you can file typically the motion to compel private arbitration at any time. This is in most credit card agreements that you can file it at any time right up until trial, or unless judgment has already been entered, like with a summary judgment or something like that. So you can file an answer and then file a motion to compel arbitration. I personally, instead of an answer, I have filed a motion to compel arbitration. And then if the court says, no, we're not going to do arbitration for whatever reason, they'll give you an opportunity to file a response. So if you filed your answer, you can file it. My recommendation is always to file the motion to compel private arbitration sooner rather than later. The longer you wait, the less likely the judge, they're going to feel like you've been wasting their time, and they may get a little bit grouchy over that. So I would recommend filing it sooner rather than later. All right. Paper Bag Hero says, is a late payment placed on a collection allowed or a violation? I might need a little bit more. If this is a Fair Credit Reporting Act violation, the FCRA is a federal statute that governs that. Late payments placed on a collection, I would need a little bit more information there. Paper Bag, if you want to give me some more information, I can kind of go into that a little bit more. Johnny 1987 says, hi, my commercial vehicle has been towed, and since I couldn't pay the fees, they destroyed it. Now I owe on the loan. What do I do? They keep calling, but I'm broke. Should I tell them what happened? Or you talk about filing bankruptcy. So I can tell you, when vehicles are repossessed, what happens is they will either sell the vehicle, or I don't know why they would have destroyed it. But anyways, if they take the vehicle, they sell it, there's a balance that's owed. It's called a deficiency balance. That deficiency balance, most lenders will file a lawsuit on that to try to collect it, because without the collateral, now that they've taken their collateral back, they've sold it, they've applied any money they got towards the balance, there's this balance that's still owed. That's an unsecured debt. There's no collateral attached to it. And they can't do anything with that unless they sue you, get a judgment, and then the judgment gives them the power to garnish your wages, bank accounts, lien property. So you could, Johnny, you could file a Chapter 7 or Chapter 13 bankruptcy. That would eliminate that completely. Alternatively, you can reach out to the lender and try to enter into some type of settlement. You're saying that, if you don't have a lot of funds right now to be able to do that, you may want to look at a bankruptcy filing, because that'll stop the collections and allow them to get rid of that completely. So, all right. M says, I want to file a response to the lawsuit, but what date do I go by since I have multiple dates? Good question. And this is something actually I get a lot, where you will get the complaint in the summons, the process server will come by, drop it off, and there's a date stamped at the top, and then you look at the summons and it says you have 20 days or 30 days or whatever it is to respond to it. And a lot of people tell me, look, the 30-day period I had to respond has already expired. What do I do? In most jurisdictions, what they do is they will file the lawsuit with the court, clerk will stamp it, and then they give them a period of time to serve you with it. And like in Arizona, the clerk will stamp it, and then the creditor has 90 days to serve you. And so the time frame for you to file your response starts on the day that they show up to your house, knock on your door, and hand you that summons and complaint. So that's what you need to look at, is the date that they bring it by. I always say, if you get served the lawsuit, I know it's stressful, but kind of get it together, put that in your phone, calculate how many days you have, and put that deadline in your phone, put a reminder so that you can make sure you file something timely on that. So let's see here. See what Rocky has to say. My attorney, who has been discouraging me from Chapter 7, scoffed at my attempts to settle with credit card debtors like CitiCard, despite it being in the contract, saying arbitration would cost $5,000. Let's see, there's a follow-up here. Credit card debt is $9,000. He said, despite my annual income, qualifies if I have over $100 monthly disposable income, no Chapter 7. Okay, so I won't second guess the attorney, because they have a lot more information than I do. So if your question is, if they're saying discouraged you from Chapter 7, there's a lot of factors that go into whether Chapter 7 works. Sometimes people qualify for a Chapter 7 bankruptcy, but maybe it's not really beneficial. I actually did a consultation today here in my practice in Arizona. The person was dealing with $6,000 of credit card debt, no home loans, no car loans, but it was causing a lot of stress. And so they were looking, should I just do a Chapter 7? I told them, look, there's never a specific dollar amount. 6,000, probably you can work some type of settlement out for almost equivalent of what it would cost you in attorney's fees and court filing fees. Not that it costs $6,000 to file bankruptcy, but I can tell you it varies throughout the country. I've seen it, $1,500 to $3,000 to $4,500. So depending on what state you're in, what the attorneys charge there locally, it may be better to look at different settlement options to be able to get it done. The whole attempt to push them into arbitration, I always say you have to do that with good faith to be ready to go forward, but it definitely gives you some leverage to try to negotiate something on the lower end. So let's see here. If Midland agrees to arbitration, would I be responsible for their fees if I lose and I can still try to settle while in the process of arbitration? This is another good question. This is something you need to, so when you file for arbitration, first of all, you're going to have to look at your credit card agreement. Your credit card agreement has to have an arbitration clause in there before you can do any type of even move for arbitration or ask the court to send it into arbitration. Read through that pretty carefully because usually there's some pretty favorable information related to who's paying for the fees. So if you go to arbitration and you lose, and I did an arbitration not too long ago at AAA, and someone hired me just to come in at the last minute, do the hearing. We lost the case. The arbitrator said, no, there's liability here. The creditor came in and asked for attorney's fees and court costs. And I responded in a written motion and said, look, in the terms and conditions, it says that both sides are going to pay for their own attorney's fees and costs associated with this. And so the arbitrator said, yeah, you don't get to come in and try to, pin these fees on this person. So, we kind of lost one battle, but won another one in that they shouldn't be able to do that, but it's going to be totally contractual. It's whatever that contract says. And if you can't find it, again, if you go to the Consumer Financial Protection Bureau, check that out. They have a whole repository of the documents, credit card agreements that you can take a look at. So that's what I'd take a look at from there. All right. And you know what? This is a good follow-up. So that you're going to know if you have a private arbitration clause by getting that arbitration agreement, the credit card agreement, and looking for the arbitration clause. How the process, just big picture. If you're in a lawsuit, you file a motion to compel arbitration. Once the court grants that, you go to, there's two main providers. There's JAMS, J-A-M-S, and then AAA, the American Arbitration Association. I typically use AAA. You go there and you're going to have to file a new case. It's pretty simple. You just do it online. They're going to charge you a filing fee of $200, roughly, maybe I think it's $250, $225-ish to file it. And then they will assign an arbitrator to the case. And then the parties will have it's kind of like an informal trial proceeding. The last ones I've been doing with AAA have all been through Zoom too. They aren't even doing them in person. And then there's an arbitration award at the end. Either you win or they win. And that's the end of it. So that's kind of what you're looking at. All right. Let's go back to my paper bag hero here. It says the collection is from a landlord from 3 years ago. Last month, when NCS updated the account, they added the late payment. I have no judgment. So the Fair Credit Reporting Act, the FCRA, states that if a furnisher of information, a creditor, if they're going to provide information to the credit reporting agencies like TransUnion, Equifax, Experian, if they're going to provide that information, it's got to be accurate. And so if the contract allows them to add late payments to the amount that's owed, then yes, they could add that on the credit report, assuming that everything's legitimate. So if the contract provides for it and it's actually being encouraged, just like interest on a credit card, those balances can keep going up. They could do the same thing here. All right, let's see here. Sorry, scrolling through this. Mario says, American Express decided to ask for my case to be dismissed. What do you think their game plan is here? And then you said I started to receive calls from the debt collection attorney's office before the judge ruled. It's interesting that you say that because I actually have an American Express case, a gigantic one, gigantic credit card of about $300,000 that someone's been sued for. And I just got notice literally yesterday in the mail from their attorney that they were dropping it. I should say this. They're filing a motion to dismiss. If you have filed an answer to the lawsuit, in most jurisdictions, the rules of civil procedure do not allow them just to drop it. They actually have to get your permission, your authorization to drop it. If they do that, if you have filed an answer already and they're filing a motion to dismiss, you could respond to it and say, I don't object to it being dismissed, but I want it to be dismissed with prejudice. If it's dismissed with prejudice, that means it cannot be refiled again. If the court dismisses it without prejudice, they could turn around, 6 months from now and refile the thing and you're still having to deal with it. And what you can articulate to the court is, look, I've already invested time and energy and money and filing fees into this. We're here. Let's do this or let's not do this. But if they're going to dismiss, if they want to back out at this point, then you want it dismissed with prejudice. Sometimes when they do that, just out of the blue, there's something wrong with their case. They found out that they don't have witnesses, they don't have documents, or there's some kind of statute of limitations issue, something like that. So you might want to look through things and see if maybe there's some type of claim or something that you have now against them because something's gone south. They don't just dismiss because they're tired of doing it. This is what they do. There's something going on with there. So, all right, let's see here. We can do one more, and then we got to finish up for tonight. Doug says, does an automatic stay stop a scheduled arbitration hearing? Also, can bankruptcy wipe out an arbitration ruling? Yes and yes. The automatic stay is the order that is entered by a judge in a bankruptcy case, whether it's Chapter 7 or 13. As soon as the voluntary petition is filed, the automatic stay is automatically entered, hence its name, automatic. Judges don't even see it. The clerk of the court, the system kicks it back to me. I have this order, and it stops everything from the minute it's filed. It stops foreclosures. It stops repossessions. Stops arbitration hearings, stops phone calls, snotty letters, emails, everything stops. There's no collections that can continue after the arbitration or after the petition has been filed with the court. In a bankruptcy, it stops everything. And yes, it can wipe out an arbitration ruling. Something that's interesting about a private arbitration ruling, it's not even a valid judgment. Like they can't garnish your wages with an arbitration award until they take it to the court and get the court to sanction it or sign off on it. They can do that, and it's not a hard process, but that's just something to be aware of. The arbitration award, American Arbitration Association is just a private company, just like my law firm is a private business, and they issue these awards, but the court will sanction them as far as signing off on them, stating that they're legitimate, and once they do that, then they can take it and pursue it. So, all right, I think that'll do it for tonight, but I appreciate everybody checking in. Again, check out our information, my link over there for the solo suit. I'll put it there in the chat section again. Great sponsors of the program. They have some cool resources that can help you with responding to debt collection lawsuits, motions to compel arbitration, and even debt settlement. Check them out. If you're in Arizona, I do free consultations. My contact information is below. And if you look below the video here, there's even a link where you can schedule an appointment where we can talk. And it is me. I do all the consultations and can kind of give you a game plan as far as moving forward. Appreciate y'all checking in tonight, and we'll catch you next week.